I will talk about the effects of war crimes in the Rome Statute on national legislation and national prosecutions or domestic prosecutions. This is an issue which I have analyzed in the past 20 years, also under the guardianship of Professor Péter Kovács as his PhD student. And I will provide in the following an essence of how the Rome Statute's war crimes contributed to national legislation and domestic prosecutions. Most of what I will say is also true or also holds for genocide and crimes against humanity, but I am focusing on war crimes. Now, just by way of very short introduction, we all know that the prosecution of grave breaches of international humanitarian law had already been an obligation in the Geneva Conventions before the Rome Statute was adopted. So the Geneva Conventions established an obligation to repress grave breaches of the conventions and the first additional protocol, and it also includes the so-called aut dedere aut judicare principle, which is basically the obligation to search for alleged perpetrators of grave breaches and either to prosecute them or hand them over to a forum that holds jurisdiction. Now, these are manifested in the Geneva Conventions. The second one is also called universal jurisdiction, which in my belief is an obligation under the Geneva Conventions. It says that each high contracting party shall be under the obligation to search for persons alleged to have committed grave breaches, etc., etc. So this means that this establishes a universal jurisdiction with respect to these crimes for all states. Now, this background shows that basically the international criminal legal system puts the first and primary obligation on national jurisdictions to try persons who have violated these rules. At the same time, and then coming now to the list of war crimes, the list of grave breaches and the list of war crimes in the Rome Statute are obviously not the same. The list in the Rome Statute is much, much wider, much longer. Having said this, we also all know that the Rome Statute itself does not put any obligation on states to prosecute Rome Statute crimes. There is no obligation in the Rome Statute to implement these crimes. However, for various reasons, in big part due to the complementarity principle, states felt and still feel compelled, not legally, but somehow compelled to implement Rome Statute crimes, even those states that are not ICC state parties. And this wave of implementation is something which we could witness beginning with the early 2000s. While I was working with the International Committee of the Red Cross as a legal advisor, I had the opportunity to assist many states in Central Europe on how to implement these crimes in their criminal codes, and it was not easy. And again, the surprising factor was that even non-ICC members, and even states that knew that they would not join the ICC, started implementation processes. And this is important in my view. I remember when the Rome Statute entered into force, there were many, many publications on what will be the effect of the International Criminal Court and international criminal justice as a whole. And many authors, including many of us here, highlighted the fact that it's not only the ICC's own procedures that will be very important and in many cases have symbolic values, but also contribute to the development of international criminal law, but also the secondary effect of kind of pushing states to implement these crimes may be, if not even more important, an even more important or equally important contribution of the ICC to the development of international criminal law or international criminal justice. This wave of implementation started in the early 2000s. We all know that the entry into force of the Rome Statute was on 1st of July 2002. Many states started the implementation process before, many after, also depending on their own legal system. Hungary, just as a side note, we signed on in January 1999, deposited our instrument of ratification in November 2001, and started the implementation process after. And when I say that the implementation process is not easy, it's because there are a lot of issues that came, that were confronted with the codificators. Some of them were constitutional issues, and some of them were general issues of criminal law. Just to highlight some of these, so it wasn't only about kind of transposing the elements of the Rome Statute war crimes into the criminal codes, but there were other aspects such as, or additional issues such as the, forming the grounds for excluding criminal responsibility, the possibilities of amnesty for war crimes, immunities, which is largely a constitutional issue, or the issue of statute of limitations or time bearing not being applicable for war crimes. Now, these are additional issues that those who codified these norms had to take into consideration. This is so because the internationally formulated crimes, such as war crimes or grave breaches, many of these questions are not left to the discretion of state authorities. We all know that one very important manifestation of state sovereignty is that it can form its criminal legislation the way it wants, excluding cases where international law puts an obligation to prosecute crimes in a certain way. And again, it doesn't only mean which crimes we put in the criminal codes, but other factors. So these other issues also needed adequate implementation, which was in many cases very, very complicated. And we also have to note, and I will come back to that, that even if proper implementation is done, even then, is not done, sorry, so even if a state would not implement war crimes adequately, even then, judges can apply international law directly in domestic courts, but there is a very big ambiguity here, and this can be confronted with many, many hurdles. I will come back to this. This is the issue of direct application of international law, which is not to be confused with self-executing norms. For example, if a state does not specify that war crimes are not subject to statute of limitations, still this is a present obligation in international law. So in a certain case, and I will come back to that, a judge could himself or herself, based on international law, interpret basically international law and say that for this and this crime, international crime, there is no statute of limitation. We started by saying that there is no obligation under Rome Statute to implement these crimes, but we also said that most states did implementation. Why? Basically for two reasons. Obvious reasons, or one is obvious, the second is not that obvious. The first one is to escape ICC jurisdiction. The ICC will, under the complementarity principle, examine whether the state carried out genuine procedure, a state concerned carried out genuine procedure, and if a state could not carry out a procedure because of lack of adequate legislation, that could result in the ICC having jurisdiction. And of course, many states wanted to avoid this. This is where we come to non-ICC member states as well, whose nationals, based on the territoriality principle, could also be drawn to The Hague. The second obvious reason, or less obvious reason, for this implementation wave was that if these are not, and this was true mostly for dualist states or dualist kind of states, that if these crimes are not implemented, then states would have to directly rely on international legal norms in their domestic procedures, on international treaties, and on customary law, horribile dictu, which is something that is in domestic procedures, something the judges don't like. And this is something that the states wanted to avoid, both in terms of legislation and in terms of application of the law. A third element, or why states wanted to implement these crimes, was the requirement of certainty and clarity of national law. These are basically human rights law requirements, which is also an important factor for judges and prosecutors. And this kind of triggered the need to implement these crimes and also the conditions for their prosecution. From the judge's perspective, national law is much more familiar. It's something they can find their way around. It's more defined for them. There is more clarity in that. And so they like to move around in those circles. And that also triggered, implementing aspects. As following element for this was the questions of sovereignty. The states implementing these crimes themselves gives them a kind of feeling of sovereignty, and I'm saying kind of because international law already puts the frameworks on how this should be implemented, but still on how other questions that are not defined by international law can still be defined by the legislator. And this is kind of, this shows a kind of manifestation of states on these issues as well. Having said this, we know that many of the conditions of the prosecution of these crimes is also defined in international law, such as the non-existence of statute of limitations, but there are certain aspects where international law gives leeway for national legislators, such as the issues of sanctions or penalties for these crimes. But even here, if a state would issue a very, very small or very light sanction for a war crime, for example, or any other international crime, it could be that international law deems this, not adequate. In addition, and this is something I personally experienced when we dealt with this implementation works, was the issues of criminal justice guarantees. In many cases, and again, also this came more apparent in dualist states, there were questions of nullum crimen sine lega in national cases. We had a certain number of constitutional court decisions which tackled the same issue, and it had to be expressed by the Constitutional Court of Hungary that if a judge directly applies international law in a proceeding, it does not violate the nullum crimen sine lega principle, because in these cases the conditions, the existence basically of the legislation is in international law. And even though this has been expressly expressed in a constitutional court decision, still, for example, in Hungary, there was a general feeling for the things for the reasons I earlier outlined, that still is much better to implement these crimes and put them into the criminal code than just to leave the judge to struggle with them. The same issue arose with the question of nulla pena sine lega, with a bit more teeth. And also what I have mentioned, the clarity of legal norms. Now, if we just think about an example of what would happen if there would be no implementation, and I can tell you certain examples from our own Hungarian case. So, what would happen if there is no implementation of crime that is in the Rome Statute? In this case, the judge could rely directly on international law. And if the judge kind of like steps over this hurdle, which again I will come back to, it's not a small hurdle, then, so if there is adequate procedure, then the ICC could not gain jurisdiction. When it comes more tricky is what would happen if there is a certain war crime where there is no international law obligation to prosecute, but it's in the Rome Statute, and if it's not implemented. Again, I have stated that the list of grave breaches and war crimes are not so the grave breaches in the Geneva Conventions is not the same. I mean, the Rome Statute war crimes list is much, much longer. There is an understanding that war crimes are the ones which are in the Rome Statute. There is no clear understanding that all these war crimes are also there is an obligation to prosecute them on the national level based on customary international law. There are new war crimes in the Rome Statute as a result of amendments where there is no general understanding that these would be, there would be an obligation to prosecute them under international law. And as we said, there is no obligation under the Rome Statute to implement them into national criminal codes. So if you are confronted with a case where there is a crime that is not in the criminal code of a state, but if there is an international law obligation to prosecute this crime, then the judge could directly apply this norm and prosecute directly based on international law, with all the hurdles I'm going to come back in the second point of my presentation. But if we are confronted with a crime where there is no international law obligation to prosecute, but it's in the Rome Statute, for example, one of the new war crimes or newer war crimes, then the judge would not be able to rely directly to international law, so would not be able to to prosecute this crime. And if we are talking about if the ICC would have jurisdiction, then the ICC could seize the case because of the complementarity principle. I hope that was kind of clear. So what I'm saying is basically this is why states implemented these crimes. Now I can tell you a specific example, but not with respect to war crimes, but crimes against humanity, and I'm not sure if you wanted to also elaborate on that, but it's the same mechanism, the Biscu case in Hungary. There was a case 10-ish years ago where a person was there was a file submitted to the prosecutor requesting prosecution for crimes against humanity committed in after the 1956 revolution in Hungary, and crimes against humanity. Well, it did not appear. This crime did not appear in the Hungarian criminal code, and so the prosecutor did not press charges. The prosecution obviously did not want to reach back to customary international law, so it wasn't implemented, and the prosecution did not look at customary international law and did not press charges simply because it wasn't in the Hungarian criminal code, even though the international law obligation was there in customary international law. And so then the legislator had to pass a law where they basically repeated crimes against humanity as it is in customary international law in a Hungarian law, and then the prosecution started the proceedings. So basically the result was that we could again see that prosecution and judges, domestic judges, like to look at the criminal code and not further. So they don't like to go back directly to international law. I will come back to the question of why. So this also showed the need for domestic implementation if you want to be safe or effective. And now coming back to the issue which I have, and being aware of time, the second point is what are the judges' problem and what's the effect on national prosecutions or national jurisprudence? There are basically two kinds of issues here. One is legal issues or a natural reservation of judges to deal with international law directly, and the second one entails practical aspects. The legal issues or reservations of judges is basically that they don't know this field of law, jurisprudence, the exact elements of crimes, commentaries. The development of these crimes is to be found in international jurisprudence. There are also language issues, so national judges may not, speak English, other languages. They not be able to reach to these documents. So there is a great hesitance from national judges to work with international law directly. Having said this, it's even if a crime is implemented in a domestic criminal code, they will have to, for the reasons I said. The international jurisprudence cannot be avoided in these cases, even if it's a domestic case and even if it was implemented in a criminal code. The practical aspects why judges are kind of hesitant to deal with international law directly is basically that these are very, very long cases. They are usually very complicated, very expensive, very difficult to have evidence, very difficult to have witnesses. Sometimes, witnesses and evidences to be found very, very far away. Plus, and this is something which we explored in a conference we organized for judges, it's very bad for their statistics. And this was something which is a very important point, and it was an eye-opener. It's like, you get a war crimes case and then you are lost for years. And there is, you have to kind of learn a totally new field of law, which you had nothing, you knew nothing about. You have to speak at least English to read the documents, and it's something very important. So judges are kind of like trying to avoid, with all means possible, national judges, these cases. So the countries where they were confronted with more of these procedures, they established mechanisms to motivate judges to take up on these cases with procedural amendments, which were very, very important to motivate them. If you look at the numbers, I cannot tell you an exact number of domestic trials on war crimes, but there are above 200. There have been above 200 domestic war crime trials since the end of the Second World War, and I'm just talking about truly domestic war crimes trials. This is not an exact number, but this is a rough number. Many of them are still currently taking place in the US, in Israel, in Bosnia-Herzegovina, Netherlands, Denmark, Sweden, These are the usual suspects, but also other states. And basically the experience is that war crimes procedures, domestic war crimes trials are more effective if states set up so-called war crimes units. War crimes units are kind of like coordinating mechanisms where they establish coordinating channels or communication channels between the adequate authorities, immigration authorities, law enforcement, investigators, prosecutors, and judges. It's basically a procedural network, but at least they know who to, call if they have cooperation issues. Now, in those states that established war crimes units, this became a strategic issue, so it requires a strategic decision by the state. But again, there is a parallel connection between the existence of a war crime unit and the number and success of domestic war crimes trials. So basically, I did not hear any bell, but I'm at 21 minutes. Yes, but I'm still aware of time. So basically, as a summary, again, even though there is no obligation in the Rome Statute, the adoption of the war crimes brought about a big wave of domestic implementation, really within 5 years. It was and then states talked to each other and who did what, how, and constitutional issues and all that. So it was really a big development there. And again, I strongly think that one contribution of the ICC to the international criminal law is this, that criminal codes are more up to date with these crimes. Thank you very much for your attention.